the common law and principles of equity. So we said the common law is actually the traditional English law. It's a traditional English law. So basically the law that was actually applied or was actually based on the traditions of the English people, the traditions of the English people. So we saw the major characteristic of this particular source of law was what we call a writ system. So it was actually based on a writ system. Then number two, it was actually also based on what we called stare decisis. Stare decisis. So making decisions are based or basically by just applying what was actually basically decided upon like the previous time. Or basically we can be able to talk about based on what we call case laws. Case laws. So these were the two major characteristics of this particular system we are calling the common law. But we say that this system actually had some shortcomings or disadvantages. It had shortcomings or disadvantages. For example, in the case of the writ system, because you are saying we had the common law courts that actually applied this, they applied this. So these were the two major characteristics of this particular source of law, or basically law system. So when you talk about a writ system, it is simply an order. This means that an order actually originated from the common law courts, asking the police to be able to arrest a person or arrest the defendant to be brought before the court. But we said most of the times the police were actually usually bribed, and many times those persons who had actually committed an offense were not actually able to be brought before the court, and therefore the case could not actually commence before a common law court. So that was actually a disadvantage, one of the disadvantages, that basically there was cases of bribery that could actually happen. Then when you talk about stare decisis, this is basically what we are talking about. Judges were making decisions based upon decisions which had actually already been made or previously. So they simply unified the way of actually making cases. So it simply meant the judges could not actually think outside the box, but basically they were actually making decisions based on past or previous decisions that had actually already been made before the court. So apart from that, we said that this particular common law system was not actually recognizing things like, for example, trust relationships. So a scenario whereby we have a trustee and a beneficiary, So their rights were not actually basically protected under this particular common law system. So it simply meant that, for example, if this trustee had not actually been paid a fee for the work he has done as a trustee, there's nothing that he could actually be able to do against the beneficiary, because this law system was not actually recognizing such kind of relationship. So then also borrowers were not actually protected. So borrowers were not protected under the common law. So that was actually another disadvantage. So we said as a result of these particular shortcomings, they had to come up with what we call the principles of equity, So these principles of equity basically meant that if you didn't get justice under what you are calling the common law courts, you could actually basically apply for basically a review of your case, or appeal the case that had been determined by a common law court judge at the King's Council. So we used to have the King's Council. So this King's Council was actually headed by the King, who had actually appointed a chairman, basically to be able to listen to or guide the other judges at that particular King's Council to listen to any appeals that actually arose from the common law courts. So if you didn't get justice under the common law system, then simply it meant you could actually be able to apply for an appeal at the King's Council. At the King's Council, basically they applied the principles of equity, which we are saying they were developed so that they could actually be able to try and actually resolve the shortcomings or disadvantages of what you are calling the common law. Because if you don't get justice at the common law, simply you basically apply to the King's Council for like an appeal. And of course, they'll apply the principles of equity to be able to resolve such kind of a dispute before the King's Council. So I think we were to start looking at now these particular principles of equity one by one. So the principles of equity, so we have like 12 of them. So number one, the first principle of equity simply states that, the first principle of equity, it states that he who seeks, so number one, it states that he who seeks equity must do equity. So he who seeks equity must do equity. He who seeks equity must do equity. Number two, he who comes to equity must come with clean hands. So number two, he who comes to equity must come with clean hands. They must come with clean hands. Then number three simply states that equity is equality. Equity is equality, equal. It basically means everyone should be treated equally. Equity is equality. Then number four, equity looks to the intent. Equity looks to the intent or substance rather than the form, Then number five, equity regards as done that which ought to be done. Equity regards as done. Equity regards as done that which ought to be done, Then number six, principle number six, it says that equity imputes an intent to fulfill an obligation. Equity imputes an intent to fulfill an obligation, Then number seven, equity acts in personam or in person. Equity acts in personam or in person. Number eight, equity will not assist. Equity will not assist a volunteer. Equity will not assist a volunteer. Equity will not assist a volunteer. Then number 9, equity will not suffer a wrong. Equity will not suffer a wrong to be without a remedy. 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 Then number 10. Equity does not act in vain. 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 Then number 11. Number 11. Delay defeats equity. Delay defeats equity. Delay defeats equity. Then the last one, number 12. Equity aids the vigilant and not the indolent. Equity aids the vigilant and not the indolent. So those are the 12 principles of equities, which are actually being applied by what we are calling the King's Council. The King's Council. So the King's Council, basically, it is a council that has been formed by the king. So this particular king had actually appointed a chairman of that particular King's Council to get all the appeals from the common law courts. And of course, they were actually applying these particular 12 principles of equity to resolve any matter that came before that particular court. So some of them are self-explanatory. So what you can be able to gather from that. So maybe we can go through some of them. So like, for example, this one, number 12, it says equity will actually always aid a person who is very vigilant and not an indolent person. So what they mean by an indolent person is person who does not actually basically act very fast, or basically you can be able to say a lazy person. So in this case, we mean that what we mean by this is that for you to be able to get equity before this particular court we are calling the King's Council, you are supposed to act within reasonable time, or basically bring the case before maybe its relevancy actually elapses. For example, if someone has basically stolen from you, so you must actually be able to bring the case while the evidence is actually quite fresh. Because if you don't bring the case immediately, basically it means that the evidence might actually be destroyed. So it simply means that you should actually always be vigilant in case someone has done to you a wrong, for you to be able to get what we call equity, or basically for your case to be heard and actually be listened to by this particular King's Council. So this particular principle simply states that for you to get justice before this particular court, then you must actually be very vigilant, or bring this particular case within a reasonable time before, so that it can actually be resolved while it is still fresh, or the evidence is actually quite very fresh. You don't have to wait for a very long period of time or be indolent. So you should be vigilant for you to be able to get justice. So that is basically what they mean by that. And of course, if you look at this particular principle, it is currently actually being applied, for example, in courts here. So there are certain cases that you must actually be able to bring before the court within a specified time, or a time specified by the judge. So if you fail to do so, it simply means that that particular case can actually be thrown out of the court. So that's what they mean by actually equity or justice will actually always aid that person who is actually very vigilant, or maybe is not actually indolent, or maybe lazy. Delay defeats equity. What they simply mean by that is that certain matters should actually be listened to or expedite very fast. So if there is any form of delay, it simply means that someone won't actually be able to get justice. So always that there have been complaints that certain cases have been before the court for a very long period of time. So maybe 20 years or maybe 30 years. So it simply means that, for example, if it is a dispute over land, if you don't resolve it very quickly, the person who's supposed to benefit from the land won't get any benefit. Maybe he's supposed to till the land and, of course, grow some crops there. So there's a dispute over the land, so he can't actually be able to take over the land. So it simply means that in such a case, if you delay justice for such kind of a person, you are not practicing what we call equity. So that's what they mean by delay will normally actually defeat what we are calling equity, or basically will actually defeat what you are calling justice, will defeat what we are calling justice. So we said, so we've been able to look at this and this. So we have equity will act in personam, or actually in in person. So basically, they will determine before the court of law or before this particular court, they'll determine the affected parties. So that particular affected party is the one who's supposed to bring that particular action before the court of law in person. So if the wrong is done to you as a person, you're the one to bring the action before the court of law. So equity or justice will actually favor the person who is actually acting in person. So you're supposed to be the defendant before the court, or basically be the plaintiff before the court for you to be able to get the justice we are talking about. So it will actually always act in person. So the person who brings the case is the one that the court will actually be able to listen to as the plaintiff. And of course, if there's any ruling, it will basically be in the favor of that particular person who has brought that particular case. So it is actually always acting in person. Equity will not actually assist a volunteer. Equity will not actually assist a volunteer. So in this case, what they mean by a volunteer equity will not actually always favor or basically will not actually assist a volunteer. So what they mean by a volunteer, it is simply a person who has not paid any consideration, for example, under contract. So it is a person who has not actually paid for any consideration. Yes. So it is a person who has not pledged, or basically you can say pledged or paid any consideration, or price under an agreement, or a contract. That is what they mean by a volunteer. So it won't actually assist. So you must actually have basically maybe incurred a price before you can actually be favored by equity. But simply because you actually a volunteer, it means that basically justice won't actually be in your favor because you are just volunteering. So it simply means that there's not any price you've actually been able to pay. But if there's any price or consideration that is actually attached to any agreement or contract, it simply means that if that particular contract or agreement is not fulfilled, there's a loss that has been incurred. So in this case, it simply means that if the contract is not actually fulfilled, you are going to incur loss. You are not actually a volunteer. You are not actually a volunteer. So a volunteer is simply a person who has not actually played or paid any price under a contract or actually an agreement. So for such volunteers, they won't actually be protected in any way by equity or justice. It must actually be realized that this particular person has incurred an expense or a loss, or basically has incurred a price under a contract for him to actually to be protected by equity or justice. So it will actually always, it will not actually assist a volunteer under an agreement or a contract. Then the next one, equity will not suffer a wrong to be without a remedy. So what they mean by this is that always under equity or justice, there must be a solution. If you bring any case before the court, there must be a solution. The judge must actually make a ruling. So there's no way basically there could be a wrong that has been done under equity and you fail to get a remedy. Always the courts of law basically will provide a remedy or a solution. They will give a judgment at the end of the case. Then equity does not actually act in vain. Equity will not actually act in vain. It will basically give a solution or basically give penalties or fines to any person who will be found to have actually been guilty. So justice won't actually act in vain. Equity does not actually act in vain. It will basically provide a solution and of course penalize or fine any person who will be found to be wrong. This one, he who seeks equity must actually always practice equity. So if you are seeking for justice, you must be a law-abiding person. So you must actually always also follow the procedures or processes that have been put maybe by the courts of law. So if they say you appear before the court on this particular date, you must actually always also appear at that particular date. So anyone who wants to get equity or justice must actually always practice justice. So it simply means that you must actually also be a law-abiding person before you can actually be able to get justice under what you are calling equity. He who comes to equity must come with clean hands. So you must have not actually been involved in committing of the wrong, and then you bring the same case before the court of law. So you should actually be able to come with clean hands and of course provide the required evidence or any evidence the court will call upon you to be able to provide. So you should actually be having what you are calling clean hands. No wrong can actually be attached to you in that particular case or action you are bringing before the court. Equity is equality. So equity, under equity, everything is, every person or every party will be treated to be equal. For example, if it is subdivision of property between a dispute between a husband and a wife, under equity, what they'll be able to do or what they used to do, it is simply to share the properties between these particular two parties in 50% ratio, because equity will always recognize that each and every person is actually equal. So if there's a dispute between the husband and wife, so there's a divorce, any share of properties or properties in such a case will be shared equally among the parties. So that is what they mean by equity, is actually equality. Every person should actually be treated equal before what you are calling equity. Equity looks to the intent, substance, rather than the form. So it looks at basically what was the intention of maybe committing a particular wrong, where they look at the, for example, the origin or what necessitated that particular wrong to be committed or that particular action to be done by a particular party. So they'll be able to look at several things that led to committing of a particular wrong before they can actually be able to make a judgment or actually a ruling. So a lot of evidence must actually be provided as to what led to that particular wrong actually being committed before the judge, or basically before the King's Council judge can actually be able to make a ruling. Equity regards as done that which ought to be done. So if in any case there is actually a contract between parties or two parties, it will only be seen to have actually been done if the terms under that particular contract or agreement have been fulfilled by the parties. So it will seem to only to have been done in case there is actually full fulfillment of that particular agreement or contract. Then equity imputes an intent to fulfill an obligation. So under equity, for example, under contracts, especially under contracts, there's actually always the intention under the terms for a certain party to be able to fulfill a certain obligation. So you are called upon as the party to be able to fulfill the obligation, failure to which it will be seen that you have actually breached the contract or agreement. So this one can actually be applied in resolving disputes under contracts under equity. So those are simply the 12 principles of equity, the 12 principles of equity. So you can actually be able to go through them in the notes. So I think they are the notes which I had shared. You can go through them one by one so that you can actually also be able to get a deeper understanding of each one of them. So they are known as the 12 principles of equity, or the doctrines of equity, the doctrines of equity. So we can look at another source of law. So I want us to look at African customary law, So this is simply law based on African customs or traditions. It is law based on African customs or traditions, our African customs or traditions. So these traditions are basically based on our different ethnic groups, based on our different ethnic groups. When we talk about ethnic groups, we mean, for example, the Kikuyu, Kalenjin, the Luyas. So they have their own traditions or customs. So they have their own standard ways of doing things in their communities or societies. So those customs have actually been unified, and they are basically observed by each and every person in that particular community. So if it is maybe to do with payment of dowry, or maybe how they carry out particular ceremonies, or how basically maybe they carry out their prayers when a person is being married, how they carry out their procedures or processes. So they have standardized them, and they're actually observed by each and every person. So that is, of course, a custom which has been observed by that particular community for a very long period of time. So it is like a law, or basically a rule, that must be fulfilled by each and every person in that particular community. For example, if it is to carry out a particular ceremony, there's a standard way they do it. If it is a burial ceremony, there's a standard way they do it. So those are simply customs which have been practiced by that particular community over a long period of time. So it is like a rule, or now a regulation, that is being followed by that particular community. So that's why we are saying this is simply law that is actually based on our African customs or traditions. So what you have to remember, when we learned about the Constitution, we said that all the other sources of law basically will be subject to the Constitution. So they must actually basically be in conformity with the requirements of the Constitution before they can actually be observed as a law. So it simply means that not all customs can actually be seen as being a law. Only those ones that can actually be able to conform with the Constitution can actually be considered to be sources of law, or can be seen as being laws that can actually guide people how they associate or conduct themselves in a particular society or community. So what are the characteristics for an African custom? So characteristics for an African custom, to be considered as being a law. What are the characteristics? Characteristic number one, it should be reasonable. 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 It should be reasonable, i.e., what we mean by this, it should be reasonable, i.e., it must be consistent with the principles of justice. It should be consistent. It should be consistent with the principles of justice, with the principles of justice. The principles of justice. Then number two, characteristic for it to be considered as being a law, number two, it should conform with the statute law. It should conform. It should be in conformity. It should be in conformity with the statute laws, It should be in conformity with the statutes laws. So what do you mean by statute laws? If you can remember very well, we said it is acts of parliament. So we have acts of parliament there as a source of law, and we have the Constitution. So for that custom to be considered as being a source of law, basically a law, it should actually basically be conforming or in sync with what is actually contained in an act of parliament or the Constitution. So it should be in conformity. It should be in conformity. What we mean by this, it shouldn't actually be against the requirements of any statute law. Then the number three characteristic, it should be a custom that has been observed by a society openly, and not by being forced. Number three, should be a custom, which has been observed openly by a society without any coercion or force, or being forced. So each and every person is actually comfortable with that particular custom. It shouldn't be a custom that is being forced to be observed by the people of that particular community. Then the last one, it should be a custom that has been observed since time immemorial. Should be a custom which has been observed since time immemorial. So this means for a very long period of time. So no one can actually be able to tell where this particular custom actually originated from. So it should be a custom that has been practiced for a very long period of time. Even if you ask your forefathers, they can't tell where this particular custom originated from. So people have gotten used to it in that particular society. So if these characteristics are actually present in a custom, then it can actually be seen or be considered as a law, basically a source of law. So only those African customs which have these particular characteristics are the ones that can actually be observed as being laws or being rules that can actually be able to govern the conduct of people in that particular society. So what we simply mean is that we can't actually be able to run away from our customs. So there are things that we found that are being practiced. So some of them are actually very good to be able to observe. So we can't run away from them. So some of them are actually still being observed by us. And of course, they can still be considered as rules or regulations that can actually be able to conduct or enable us how we can be able to associate in our society. So some of the cases, so you can look at some of the cases under which the African customary law can be applied include, so cases where African customary law can be applied. Cases where African customary law can be applied include cases. So if there's a case in a court of law, which kind of case can they apply African customary law? So cases which African customary law may be applied. Cases which African customary law can be applied include the following. So number one, we have dispute over land held, dispute over land held under African customary law. So number two, another dispute or another case. Number two, marriage, divorce, or maintenance, marriage, divorce, or maintenance. Another one, marriage, divorce, or maintenance, seduction or pregnancy of an unmarried woman or girl, seduction or pregnancy of unmarried woman or girl, unmarried woman or girl. Then we have intested succession. Intested is simply where there is no will that has been left. Intested succession or administration. This is where a person has not left a will to administer his property, or how his property can be shared among his next of kin. So they'll apply the customs in that particular community on how they can be able to subdivide the property. So they'll say the last born will be here, the first born will be here. The girls will take this particular share according to the customs of that particular community, So these are some of the cases. So we can add another one. Adultery. We can talk about adultery. Adultery with a married woman. If a person commits adultery, so what normally happens in that particular community if a person is found to have committed adultery? So there are practices or traditions they have that must be fulfilled for any person who has actually committed adultery. So most of these are actually what we call civil cases. So they are civil cases, not criminal cases, civil cases. So most of the civil cases will be resolved under the African customary law. So some of the civil cases will include what we've just listed. So maybe in the exam, they could ask, what are some of the matters that can be resolved under African customary law, So that is what we mean by African customary law. So it is simply laws that are actually based on our African customs. What we've said before they can be applied as a source of law, they must actually be having certain characteristics. So they should be very reasonable. They should be customs which have been observed openly without any form of coercion or force. It should be a custom that has been actually been applied for a very long period of time or since time immemorial. They shouldn't be inconsistent. They should not actually be inconsistent with written laws. So the written laws include, for example, statutes or maybe the constitution. If they are not consistent with that particular those particular two sources of law, it simply means that they cannot actually be applied as a source of law or as laws So we can look at another source of law. We can look at judicial precedents. Judicial precedents as a source of law. Judicial precedents. Judicial precedents, or sometimes we call them case laws. Judicial precedents or case laws. So what we mean by judicial precedent or case laws is that sometimes when judges are actually making rulings or basically determinations before the court, so they could sometimes make a reference to previous rulings or basically rulings that have been made by superior courts. So if they do such, we say that they're actually applying what we call judicial precedents. So it is actually also based on what we've just learned, the principle of stare decisis, which simply means stand on decided cases. So this is simply a legal, you can just be able to define, it is a legal rule that requires judicial precedent. It is a legal rule. It is a legal rule that requires, judges, It is a legal rule that requires judges hearing a case to refer to earlier cases, hearing a case to refer to earlier cases, decided by decided by his predecessors, or those who came before him, predecessors, decided by his predecessors, in order to find material facts, in order to find if there are, you can say if there are material facts relevant to the case at hand, So it simply means that before the judge makes the ruling, he can actually be able to make reference to previous rulings or cases which have actually been determined before the court. So by his predecessors, the judges who came before him, maybe 10 years ago, 20 years ago, or in a different jurisdiction, or maybe a judge who is actually maybe in another court, as to how he determined a particular case, so long as the facts are actually similar. So if it is a similar case, then he can actually always be able to make reference to that particular ruling, that there was actually a ruling that was made by this particular judge in this particular country. The year was this and this, and the ruling was actually basically based on these particular facts. So these facts, he tries to relate them with what is actually now at hand or what is actually handling. So it just basically, it is used as a basis of building on a ruling that will eventually be made or basically will be declared by the judge. So if he does such, we say this particular judge is actually basically applying what we call judicial precedent. So it is simply whereby a judge makes reference to previous rulings that have been made by his predecessors. So if the facts are actually quite similar, he'll make several references to that particular ruling so that he can actually be able to justify his final ruling or the ruling that is actually going to make as a judge at that particular point, or the case he has at hand. So that's what we mean by judicial precedents. That is what we mean by judicial precedents. So we can have different types of judicial precedents. So we can have different types. So you can just put a brief description or summary of some of the types of judicial precedents that we can actually be able to have. So we can have types of precedents. So types of precedents or judicial precedents that we can actually be able to have. So we can have number one, binding and persuasive precedents. Binding and persuasive precedents. Number two, we can have what we call original and declaratory precedents. Original and declaratory precedents. Then number three, we can have what we call distinguishing precedents. Distinguishing precedents. Distinguishing precedents. So you can have a binding and persuasive or persuasive precedents. You can have an original or declaratory precedents. Then you can have distinguishing precedents. So an original precedent, it is simply the law-making precedent. So we can be able to say, basically, we can be able to say that an original precedent, this one, it is a law-making precedent. So an original precedent is a law-making precedent, is a lawmaking precedent. So it is actually original in nature. It simply means that there hasn't been any such kind of ruling. So it is the first ruling that is being made. So it will set a precedent for future rulings. So people can actually always be able to make reference to that particular ruling. So it becomes original in a particular way, because in future, people will actually be able to make reference to it. So it will be called an original precedent. So it is a law-making precedent. It is simply a basis under which, or a comparison under which people can actually be able to make a reference to, because the ruling is actually quite unique, or has not actually been made by any judge across, maybe across the world, or maybe across the country, or across the courts of law, across the courts of law. Declaratory, so we have declaratory precedents. So a declaratory precedent is a declaratory precedent is the application of an existing principle of law, is the application of existing principles of law, in subsequent cases, So once it is actually on original precedent, then eventually it is actually applied in future. It becomes a declaratory precedent. It is now actually declared at future rulings. So that's what we mean by an original and a declaratory precedent, an original and a declaratory precedent. Then we have binding and persuasive. So binding, it is simply an earlier decision which binds the courts before which it is supposed to be relied upon. So for example, if it is a ruling maybe by a superior court, let's say for example the Court of Appeal. So this ruling by the Court of Appeal simply binds all the other decisions of the lower courts. So they have no option, but they'll be bound by that decision made by the superior court. So they shouldn't actually go against as what was actually basically declared or determined by the superior court. So the ruling by the superior court will simply bind those rulings of the junior courts. So the judges in the junior courts will have no option but basically to follow what was actually basically declared by the superior court, for example, the Court of Appeal, or maybe the Supreme Court. So that ruling by the Supreme Court, or maybe by the Court of Appeal, will become a binding precedent for any ruling that are supposed to be made by a subordinate court, like for example, the Magistrate Court, or maybe the High Court, which are actually lower in hierarchy compared to the Court of Appeal and the Supreme Court. So the rulings, those are particular rulings by those judges or senior judges, will bind the rulings that are supposed to be made by the junior judges. So the junior judges are actually bound. So it becomes a binding precedent. That declaration of a superior judge becomes a binding precedent, So persuasive precedent, it is simply whereby now the judge makes reference to that particular previous ruling and tries to persuade the courts that they should actually be able to agree to what he'll be able to declare, or as to the ruling he'll actually be able to make. So he uses previous rulings as a way to persuade the courts to basically agree or try to basically justify as to how or why he has made a particular decision. So he persuades the courts, so they become persuasive precedents. Those particular basically cases, he basically quotes to persuade the court or basically convince the court, they'll become what we call persuasive precedents. So just previous cases that are used as a basis or basically quite enough evidence of the judge to be able to make a ruling, or basically as a way of convincing the courts as to why he'll be able to make a particular ruling. So those cases he quotes, or basically those previous rulings he quotes, they become what we call persuasive precedents. Then you have distinguishing precedent. This is where now the judge tries to distinguish himself. He becomes very unique, such that even though there have been previous rulings that have been made with regard to the same facts or similar facts that he has, and certain rulings have been made based on those particular facts, he won't make a ruling in a similar way. What he'll do, he'll be able to distinguish himself by simply being able to state that even though this was actually basically declared by those particular judges before me. Me, myself, I'll be able to distinguish myself because those particular rulings were not actually basically maybe not proper or not maybe the correct law was actually applied in making the rulings. So therefore, he distinguishes himself by simply making a ruling that is quite unique compared to those particular rulings. So those references he makes to, they'll be known as distinguishing precedent. So he distinguishes himself from previous rulings or similar rulings that have been made, whereby we had similar facts. But of course, he won't make the same ruling as the previous ones. He will distinguish himself and come up with a unique ruling or judgment. So such a ruling will be termed as being a distinguishing precedent. So he distinguished himself as a judge to make a particular ruling, So judicial precedent has its own advantages and disadvantages. So it has its own advantages and disadvantages.
Excuse me, sir.
Yes, you have a question?
Yeah. Is there a difference between original and distinguishing precedent?
Original and distinguishing precedent.
Yeah.
Actually, they are almost similar, but now in this case, before the judge distinguishes himself, he'll quote those previous rulings, whereby we had similar rulings that were consistent by judges. But now himself, he'll basically clearly state that he won't actually be able to make a similar ruling as to those rulings that were made by previous judges. He's going to distinguish himself due maybe to certain reasons. So maybe he could actually be able to argue that the law was not actually applied proper by those previous judges who made such rulings. So therefore, he'll be able to distinguish himself. So in this case, you can actually be able to see that he clearly quotes those previous rulings and actually now distinguishes himself or tries to convince the court that he's quite unique or he has different knowledge of how to approach such kind of case, or if such facts have been presented before the court. So clearly, before he distinguishes himself, he'll clearly quote the previous rulings that are whereby we had similar facts and the judges made similar rulings. But of course, for him, he'll be able now to clearly state, I distinguish myself, or basically I make this particular ruling on this particular case, but I won't actually be able to make reference or make a similar ruling as to those judges due to certain reasons. So he'll be able to distinguish himself, but in this case, he's actually able to quote those particular previous rulings, and how he's actually able to distinguish himself, he clearly states in his ruling. When you talk about an original precedent, so this is basically whereby, for example, the judge makes a ruling that is actually quite very unique. It has not actually been made by any other person. He doesn't make any reference to a previous ruling, but if people basically look at how those rulings are actually being made by previous judges, the expectation would be maybe the judge will take a particular position. He won't make any reference to those particular previous rulings, but he'll basically clearly make a declaration or a ruling based on the facts that are actually at hand before the court. So his ruling actually becomes very unique, or basically becomes what we call a landmark ruling. And of course, in future, several people can actually be able to make a reference to this particular ruling. So it becomes an original precedent, So the best example you can actually be able to give is that it is not actually easy to nullify a presidential election. It's not easy to nullify a presidential election, not actually even in Kenya, around the world. So you rarely hear that someone or a judge before the court has actually been able to nullify a presidential election. But of course, here we have a unique judge, so he's known as Justice Maraga. Basically, he nullifies a presidential election. So most people will actually basically expect that he won't be able to nullify it. And when he makes the ruling, he doesn't make any reference to previous rulings that have been made concerning declarations with regard to presidential elections. But basically, he looks at the facts that have been presented to him before the court, and of course makes an original ruling based on those particular facts. So that becomes a landmark ruling, and in future, basically, several judges can actually be able to make reference to this particular unique ruling that was actually made by this particular judge. So that one actually becomes an original precedent. So several judges, not even in Kenya, will actually always be making reference to this particular declaration that was made by this particular judge, because it is actually a very rare ruling that can actually be made by any judge, not even in Kenya or maybe across the world. So it becomes an original precedent. It becomes an original precedent. Yeah. So I think that is actually clear.
Yeah, I've understood. Thank you.
So we can look at the advantages of judicial precedents. The advantages and disadvantages of judicial precedents. So those are the advantages of judicial precedents. It is quite certain and predictable. So it promotes certainty in law and renders a legal system predictable. So the Court of Appeal, they have given an example there. The Court of Appeal was emphatic that a system of law requires considerable degree of certainty. So it is sometimes advantageous to make, or basically to apply judicial precedents, because it creates certainty. People are actually quite certain or quite sure of what is likely to be the outcome. So people are not actually guessing, because they'll clearly be able to make an analysis of previous rulings, and they can actually be able to see that this judge, where is actually maybe going to lead the courts, or basically which kind of decision is actually going to lead the courts to, they can easily tell. So there's usually a lot of certainty when judicial precedents are actually applied, because judgments, or basically rulings, will be seen to be very consistent. So because they'll actually be almost similar in a particular way. If it is basically a judgment or a case concerning maybe robbery with violence, it has clearly been known that previous judges have made rulings in a particular way. So quite obviously, there's a lot of certainty as to what is likely to be the outcome if someone is actually accused with what we call robbery with violence. So there's what we call uniformity and consistency. So it enhances uniformity. Rulings actually become very uniform and actually very consistent. It is rich in detail. So you'll hear the judges make a lot of references. They do a lot of readings before they come to the final decision. So when they're actually applied, it makes the judgment become very detailed. So because a lot of references have been made to previous rulings. It is practical. So the principles or propositions of law are formulated by superior courts on the basis of prevailing circumstances. Hence, the law manifests such circumstances. So it is, in this case, what we mean by this, for example, we've said that superior courts will actually be able to bind those decisions that are actually made by lower courts. So those particular rulings are likely to be formulated, or are mostly formulated, by the superior courts. It is convenient. It is convenient. The application of the case law is convenient in application, in that judges in subsequent cases are not obliged to formulate the law, but to apply established principles. It is flexible. It is contended that when judges in subsequent cases attempt to distinguish either earlier decisions as to justify departing from them, this in itself renders the legal system flexible. So it is sometimes a bit flexible when the judges try to distinguish themselves from previous rulings. Disadvantages, it is somehow rigid, in that judges won't actually think outside the box. So they'll be making rulings or judgments in a similar way. So they won't actually be careful to look at the facts at hand. Maybe they are a bit different as to what was actually presented before a court in a previous ruling or case. So it makes them become very rigid. So they can't think outside the box. So they are not actually somehow maybe flexible in a particular way. It is somehow bulky and complex. So a lot of readings or references must be made. So people might actually get tired to be able to follow. Even if they are making that particular judgment, they can read like for almost maybe 10 hours. So sometimes it becomes very bulky when a lot of references are actually made to previous cases or rulings. So that is a disadvantage. It is piecemeal in nature. So the lawmaking by courts of law is neither systematic nor comprehensive in nature. It is incidental. The principles or provisions of law are made in bits and pieces. Over subtlety or a lot of artificiality. So when judges in subsequent cases attempt to distinguish indistinguishable cases, they develop technical distractions and distinctions without a difference. it is backward looking, so it is not does not think about the future. So this simply means that a lot of things might have actually changed within a period of a span of maybe 50 years or maybe 100 years. So it simply means that in such a case, if it is backward looking, in such a case that maybe there has been some change of technology or how people approach certain matters. So if that one is not actually observed, then it simply means that it won't be relevant for the case or the facts that are actually at hand. So that is a disadvantage. Also, it is a disadvantage also. So it is backward looking. It is backward looking. It is backward looking. So we can wind up by looking at Islamic law. So what is Islamic law? Islamic law, international treaties. So another source of law is Islamic law. Then you have international treaties and agreements. International treaties and agreements. International treaties and agreements. So what we mean by Islamic law? So this is simply law that is actually based on the Quran, or sometimes we say the teachings of Prophet Muhammad, the teachings of Prophet Muhammad. So it is normally applied or practiced by the Muslims or people who profess the Muslim, and it is mostly applied to resolve civil cases or civil disputes among the Muslim people. So it is simply based on what they believe in the Quran or they believe in the teachings of Prophet Muhammad. So those teachings have actually been able to set some standards for them. So it simply means that, for example, if a person has committed a particular wrong in the society, according to the teachings, what do the teachings actually say such a person is supposed to be done, or what should be done to such kind of a person? So those teachings have actually been able to set some standards for them, and therefore they have become like their norms or rules on how they conduct themselves. So those laws are actually now applied by these Islamic people, basically the people who profess the Muslim, and it is actually applied in resolving, we've said, civil cases or disputes, civil cases or disputes among the Muslim people. So not actually criminal cases, but civil disputes. When we talk about civil cases, we include, for example, resolving matters like, for example, marriage disputes, inheritance disputes. So what do the teachings actually say according to the Quran? What actually happens, For example, if there's a marriage dispute, what is actually supposed to happen? So they can be able to use such teachings to resolve such kind of a dispute. So it is actually normally applied by the Islamic courts. So Islamic courts, or sometimes we say the Qadis courts, the Qadis courts. International treaties or agreements. So these also actually set some rules. So certain agreements between countries can set certain rules which actually should actually be observed by those particular countries. In this case, we could be able to talk about an agreement between the East African countries, so the East African community. So they can come up with their own rules under that particular agreement. So it will guide on how these particular countries are supposed to operate or actually conduct themselves. So maybe countries in Asia can come together and actually come up with certain treaties or agreements. These treaties will basically form some rules and regulations which must actually be followed or observed by those particular countries in that particular territory. So it becomes like a law governing their conduct or people in that particular society or that particular community of countries. So those are the sources of law. So I think we've come to the end of this particular topic. We've come to the end of this particular topic. So maybe we can look at another topic. We can look at another topic. We can look at another topic. So you can look at this one first, the law of torts. The law of torts, the law of torts, the law of torts. So when you talk about the law of torts or simply a tort is simply a wrong that has been committed by a person against another person. So some of the wrongs that can be committed include, for example, what we call vicarious liability, or a person can be accused of what we call strict liability, or we can have what we call negligence, or we can have what we call nuisance, or we can have what we call trespass. We can have what we call occupier's liability. So someone can be held culpable or responsible under what we call occupier's liability, or we can have what we call defamation. So these are some of the torts that we can actually be able to have. So we'll be able to look at each one of them, and under each and every tort, then what you're supposed to just to be able to understand under each and every tort is the characteristics of the torts, or basically characteristics of simply the meaning of the torts, meaning of the torts. Or sometimes you can be able to say elements or essential elements of the torts, elements of the torts. Another thing you're supposed to be able to understand is, for example, forms of defense. So forms of defense under the tort. Forms of defense under the tort. For example, when you talk about defamation, if you're accused of defamation, how do you defend yourself? Then another thing to be able to know about is what we call remedies under the tort. Remedies under the tort. What are the remedies the court can actually be able to give? The kind of relief the court can actually be able to give to a complainant or a plaintiff in a court of law. So in this case, if you've accused another person of defamation. If the first person is found to be culpable, what are some of the remedies that they can actually be able to give? Maybe they'll ask that other person to be able to compensate you. So that is a relief or a remedy. So to pay for all the losses. Maybe they can ask the other person to seek for an apology from you. So that is a remedy the court can be able to give. So under each and every tort, then you should actually be able to clearly understand what are the characteristics. What do we mean by this particular tort? What are the elements or essential elements of the tort? What are the forms of defense that a party or a defendant can actually be able to produce before the court to defend himself? And of course, what are the remedies under that particular tort, So maybe I'll just summarize them, then I think we'll be able to look at them in deeper details in our next class. So when you talk about vicarious liability, so this is simply whereby a person is indirectly accused of a wrong committed. So he's accused of a wrong committed by another person. So the best example we normally give here is a scenario whereby you have a master and servant relationship. So the wrongs done by the servant can be vicariously be accused on the master. So the master will be accused vicariously for the wrongs done by the servant. So in this case, the wrongs done by the employee will be accused on the employer. So you are an employee or a banker at Kenya Commercial Bank and you commit any wrong against a customer. That wrong basically will be accused on KCB as the company or as the master or as the employer. So KCB becomes vicariously liable for the wrongs committed by its employee or servants. So that's what we mean by vicarious liability. Then you have strict liability. So this is simply basically whereby you are accused of a wrong without even your knowledge. So there's no direct implication or direct accusation on you. But of course, under the circumstances surrounding that particular committing of the wrong, then you can actually be accused of having committed the wrong. So the best example we normally give is whereby we have two occupiers of land and we have a neighbor. So if you release anything to the neighbor's land and goes and causes any destruction, then you can actually, of course, be accused of what we call strict liability. So we normally have the essential elements. We say that there should actually be a thing. This thing should actually be able to escape. Once it actually escapes, so there should be a thing. So it's normally there should be a thing. This thing should actually be accumulated on your land or property. Accumulated through what we call non-natural use of land, so in a man-made way. Then number 4, it actually escapes and actually causes destruction, eventually causes destruction in the neighbor's property. So when you talk about the thing, for example, it could be accumulation of water. And as a result, after the accumulation of the water in maybe a reservoir tank underground, it can escape under shafts or in pipes and cause destruction in the neighbor's property. So this escape might actually be without even your knowledge, so you don't know. But eventually, it will be discovered it originated from your land. So in such a case, you can be accused under what we call strict liability for having caused destruction on your neighbor's property. That is what we mean by strict liability. So negligence is simply whereby we have a failure of duty of care. So you fail to be very careful or take a duty of care in what you are doing, for example, as a profession. So if there is any failure of duty of care, then basically it leads to damages or injuries to another party. That other party can actually be able to accuse you or accuse such kind of a person of what we call negligence. What we mean by nuisance is, for example, if there's escape of some form of gases or maybe fumes to your neighbor's property, such that you are causing that particular neighbor of yours not to enjoy his stay or basically enjoy the use of his property. If you are causing a particular person not to enjoy the use of his or her property, then you can be accused of what we call nuisance, especially if there's, for example, escape of things like maybe fumes or gases or maybe smoke or maybe even noise. So if your neighbor is playing loud music, you can accuse him of what we call nuisance because he's actually making you not actually enjoy the use of your property as a tenant. Trespass, you get access maybe to a person's goods or maybe property or land without his authority. So he can accuse you of what we call trespass. So you can have trespass against land, trespass against goods, or trespass against persons or individuals. So under trespass against persons, we have things like, for example, false imprisonment. We have, for example, battery. So those are the kind of trespass that can actually happen without getting an access or authority, or accessing another person's land, goods, or maybe injuring another person without his authority or acceptance. He can accuse you of what we call trespass. Then you have occupier's liability. What we mean by occupier's liability is that it is the responsibility of an owner of premises to ensure that any person visiting the premises that is actually quite safe enough. In this case, it could be, for example, the best example could be, for example, a supermarket. So a supermarket experiences a visit of a lot of customers. The supermarket has the responsibility to ensure, as the occupier of that particular property, that all customers walking into the premises are actually quite safe. Failure to do so, then the supermarket can be accused of what we call occupier's liability, failing to take the responsibility by ensuring all visitors, all persons who enter the premises are actually very safe. They're actually very safe. They're actually very safe. So that is what we mean by occupier's liability. Then we have defamation. So defamation is basically giving out information which is not factual or maybe true about a person without his or her authority. So you can actually be able to accuse you of what we call defamation, So those are some of the thoughts or wrongs that can actually be committed by a person against another person. So we'll actually be able to look at them, each one of them, in our next class. So we'll start with the vicarious liability, then go like that until we cover all of them, Otherwise, unless there's a question, you can ask at this particular point. So those who have actually missed the class, I think I'll be able to share the video. I want to compile the video and actually share it soon after this, so that they can actually be able to watch later during the time for the class, So I don't know if there's Harrison has just joined us, but of course, as I've said, I've recorded the video. So I think you'll be able to get access to it after this particular class, So unless there's a question from Becky. Becky, do you have a question?
Yes, there were those points that you gave us under African customary law.
Yes.
Yeah, for a custom to be relied upon as law, it must have certain characteristics. You gave us the characteristics, though I did not write two of them, the last two. Could you please repeat?
The last two. So the last two, I think I said it should be a custom that has been practiced since time immemorial. It should be a custom that has been practiced since time immemorial or for a very long period of time. It should be a custom that has been practiced for a very long period of time or since time immemorial. It should be a custom that has been practiced since time immemorial, or for a very long period of time.
Thank you.
So.
Yeah.
So I think we can end there. So let me do the video, and I think I'll share the video. You can have a good evening.